Hi everyone. So today we're going to consider advertising and improper attraction of business by lawyers. You'll find this under rules 39 to 47 of the rules of professional conduct of the RPC. So what's advertising and what's soliciting? Now you see that advertising is the making of statements by a lawyer in order to promote the quality, size, or success of his practice. While when we talk about soliciting, soliciting now is where a lawyer makes any statement or conduct in an attempt to get a brief from a prospective client. All right. So, what do the rules tell us about advertising and soliciting by lawyers? Now, under the RPC, a lawyer is permitted to engage in advertising or promotion of his practice as long as he's acting in compliance with the RPC, while for soliciting, a lawyer is absolutely prohibited from directly or indirectly soliciting briefs from a client. So for advertising, what are the guidelines under the RPC that would enable a lawyer advertise within the bounds of the law? Now, a lawyer is prohibited from advertising if his advertisement is going to be misleading or inaccurate, if it's going to diminish public confidence in the legal profession, if it is criticizing other lawyers or professionals, if it relates or refers rather to the success rate or size of his practice, or if it's so frequent to cause annoyance to this person to whom it's directed. Now, especially with the size and success rate, this is something you see inserted in problem scenarios of where a lawyer, for instance, in his advertisement is boasting that he's the winner of so-and-so case or the most successful lawyer in town or any such statement. And those would be statements that would be contrary to the provisions of the RPC. All right, so a lawyer may advertise his practice, but in doing so, he should not go outside of what the RPC permits. Now, size of the practice, just like we talked about the success rate, size of the practice is where he's probably boasting that he has the biggest law firm, employs the most lawyers, or any such thing. All such statements would be inappropriate. Now, another very important thing to be mindful of is in advertising, a lawyer is allowed to display signs or notices outside of his office building, but such signs and notices must be reasonable in size and of sober design. So a lawyer could have, right in front of his office, the name of his practice on the signpost advertised. Okay, but it shouldn't be overly large in size, and it should be sober in design, meaning it shouldn't be something so, colorful and so flashy in that sense. It's supposed to be of reasonable size and sober design. Now, some way you find this tested in questions is where you'd have, for instance, the lawyer having his signpost not in front of his office, but maybe somewhere on the road, maybe at the junction leading to his office. Of course, that would be inappropriate. That would be now going beyond what the RPC permits. It's supposed to be outside his office or building and should be reasonable in size. So if you're told that it was a very large signpost or something, again, that would be against the provisions of the RPC. Now, in soliciting, there are certain conducts by a lawyer that are very specifically forbidden. And when you look at Rule 47 of the RPC, we have the rule there concerning instigation of controversy or litigation. So that's talking about a lawyer trying to cause some controversy or trouble, which should lead to a client briefing him to take up a case on his behalf. Of course, soliciting is prohibited by the RPC, and very specifically, these acts, which we shall now look at under Rule 47, sub Rule 2, are prohibited. First, a lawyer should not search the land registry or other registries for defects with a view to employment or litigation. So a lawyer should not go searching through documents in the registries looking for defective documents and then getting someone to sue in that regard, and that would be unprofessional and wrong. A lawyer should also not seek out claimants in respect of personal injuries or any other cause of action. All right. So, for instance, where there's an accident or something that happens that causes personal injury to a person, a lawyer should not go seeking out such persons to get them to instruct him to commence proceedings against the other person. And that's why a nickname for this rule is called ambulance chasing. All right. The lawyer should not literally go chasing after the ambulance and to get the injured person to now instruct him to bring proceedings against the person who was at fault. And you see that very clearly under the next sub rule. It says a lawyer should not follow up on accidents with a view to employment as a lawyer in respect of any claims arising from such accidents. All right, so that's the rule against ambulance chasing. So these are all acts and conduct which are specifically prohibited for a lawyer under the RPC. All right, so again, the rules covering advertising and soliciting by lawyers range from Rule 39 of the RPC up to Rule 47. Lawyers may advertise, but must advertise in compliance with the provisions of the RPC, and lawyers are expressly prohibited from soliciting. Advertising simply means putting out your practice, all right, putting out information about your practice in the public, and while soliciting is specifically going after a client with a view to getting briefed by that client. So I hope you've enjoyed learning, and I'll see you another time. Bye-bye.